Good afternoon, ladies and gentlemen. Permit me to stand on existing protocols. Once again, my name is Jumoke Fajemirokun. I'm a partner at ENI Advisory, and I'm excited to be moderating this panel on the Petroleum Industry Act. As we all know, the Act was passed in 2021, and it was a long time coming, and it completely overhauls the legal, regulatory, fiscal, and institutional framework for the petroleum sector. There are a lot of benefits that come out from the Act, but at the same time, there are challenges with its implementation. So this panel discussion will highlight some matters arising from the implementation and just discuss issues around that. So we have a distinguished panel of speakers, and they will be allowed to introduce themselves shortly and the nature of work that they do in relation to the PIA. But before we dive in, I've been asked to give a brief introduction, a brief background on the PIA, just for the benefit of everyone in the room. And so, as I mentioned earlier, it's a bill that has been, or rather an act, still getting used to calling it an act. It's an act that has been a long time coming. It had been in the works for about 20 years, and finally it got passed into law in 2021. It changes the governance structure for the petroleum industry bill, creates new institutions to regulate the upstream, midstream, and downstream segments. We have representatives from the regulatory institutions here, Mr. Wachuku and Dr. Habib, who's joining us online. It also creates new licenses, a new licensing framework for the upstream segment, basically changing the nomenclature from oil exploration, oil production, oil mining leases to petroleum exploration, petroleum prospecting, and petroleum mining leases, and provides for a stricter acreage management regime. So if you don't use it effectively, then you stand the chance of, you risk losing it. What's interesting about the bill as well is that it provides extensively for the midstream segment, creating a new licensing regime for gas that did not exist before. And also we have provisions around economic regulation, so price regulation, competition regulation, as well as access, third-party access regime. It also touches on host community relations, which it has been a touchy topic over the years, and provides for the creation of a host communities development trust where operators are required to contribute a minimum threshold of their operating expenditure into that fund. And most importantly, introduces a new fiscal regime. Upstream operators are no longer, well, if issues around conversion, but if they choose to convert to the PIA licenses, then they will no longer be subject to the petroleum production, petroleum profit tax. And there's a new hydrocarbon tax together with the company's income tax that will apply, depending on the terrain that they're operating in. And also we have new innovations like a decommission and abandonment fund and the likes. And so, without further ado, I'd like to turn on to the panelists now. And first, I'll be asking them to reintroduce themselves and let us know the nature of work they do or have done in relation to the PIA. And if we can start with our panelists that are present here. Mr. Wachuku.
Thank you. Good evening, all. Yes, my name is Charles Wachuku. I'm with the NMDPRA. I have core responsibility for stakeholder engagement and regulations. So what we try to do is basically meet with all our partners, companies, holders of our licenses, and give them a sense of the direction that we feel the industry should be going. We have regular conversations with everyone, including the NBA and other industry bodies, OPTS and IPPG alike. We're also, like I said, we also work on our regulations. Quite a few of them have come out now, and that's what we're really up to right now. Thank you.
Ms. Tyrell?
Good evening, everyone. My name is Aditola Taiwo. I'm a senior legal counsel with the Shell Petroleum Development Company of Nigeria. Should I say the work I do on the PIA is been a long time coming. I've been monitoring the act since it was a bill for over a decade. And I also work with other industry operators to review the various versions of the bill and the act finally within the oil producers trade section, that's the OPTS. So in a nutshell, that's my own experience here. So.
Thank you very much for that. May I turn to Dr. Habib, who is joining us online?
Okay, thank you very much, moderator. My name is Dr. Noor Habib. I'm an Executive Commissioner of Development and Production in the Nigerian Upstream Petroleum Regulatory Commission. Coincidentally, also a member of the Presidential Steering Committee on Implementation of the PIA. My involvement in PIA pretty much dated back to quite a long while. On this specific milestone that we were able to collectively achieve, I was part of the team that developed the concept, designed the framework, and drafted the law. And now we are collectively putting all necessary machineries to ensure that we implement the intentment of the law as much as possible. Thank you.
Thank you very much. Dr. Adefulu.
Thank you, Madam Moderator. Good afternoon to everyone on the panel, and good afternoon, SBL. I'm very glad to be here to join you virtually to speak on, well, Petroleum Industry Act, which I've spent, like members of the panel, I've spent many, many years working on. So I have advised private sector and the government, and worked very closely with Dr. Habib, as well as other members of the panel on different elements of the bill. So I look forward to talking about that, and also the fact that we've been advising both indigenous oil and gas companies and I would say the international companies on various aspects of implementing the Petroleum Industry Act. Thank you.
Thank you very much. Okay, so I gave a brief overview of the PIA, and I mentioned that there are a number of issues that arise from its implementation, but we can't discuss everything here. In fact, there was a session on Wednesday, a half-day session, and even at that, we couldn't discuss everything. So this panel will just focus on a few issues, and we'll start with the institutional reforms, the institutional framework. And so I'd like to ask Dr. Habib, we have new institutions that have been set up. What are the key differences between what we have now and the past regime? Is it just new names, new bodies, or is there something different that they offer?
Thank you very much. Thank you very much, okay. I think this is a very important question which underpins the philosophy of the PI itself. Typically, the institutional framework or the governance framework within the industry prior to now is flagged by a significant amount of confusion and amorphous nature, whether it's in the policy space, whether in the commercial environment, or whether in the regulatory space. And typically, like we all know, the Minister of Petroleum Resources used to be the policy anchor, the chief commercial custodian, and also the chief regulator of the country. And that's basically evidenced by the fact that NNPC Act 1977 mandated the Minister of Petroleum Resources to be the chairman of the board of NNPC. If we go to the regulatory environment, the Minister of Petroleum rightly and aptly have direct responsibility to oversee and supervise the activities of the defunct DPR, which had the technical regulatory responsibility across the value chain. Now, of course, the policy space is its own, but because of where we are coming from, typically from history, from military, from the military framework to migrating to democratic dispensation. NNPC now, over time, gained some capability and impetus to begin to play within the policy environment, which completely is not its space. In the other space, NMPC also, because the regulatory institution called Petroleum Inspectorate, which later transformed to the DPR, was part and parcel of the NMPC by law. So the NMPC sees itself also as a regulator. And that presents a significant amount of challenge and uncertainty in terms of really setting the rules straight ahead in terms of governance, because that means a businessman sitting somewhere in Singapore, anywhere in the world, there's no clarity. The minister is everything, the regulator doesn't have the enablement of doing what he has to do in terms of independence and sound legal framework. And also the NMPC minister itself, his attention is diverted, is distorted into either regulatory or policy framework. So the fundamental value with respect to difference from where we were and where we are today is the fact that for the first time, PIA put a governance framework that clearly sets rules and accountabilities across the policy, commercial, and regulatory space in the industry. And that's the reason why when you look at the law today, the ministerial powers have been purely constrained and ring-fenced to policy matters. The regulators, which is the Upstream Petroleum Regulatory Authority and the Midstream and Downstream Petroleum Regulatory Authority, they are basically contemplated and designed to be independent regulators that can have all the necessary enablement with respect to powers and accountability mechanisms to be able to not only regulate the industry, but also this time around serve as value enablers and investment enablers that can ensure that there is value creation to enhance shared prosperity in the industry. This is a very big difference. And that is why when we recall what the defunct DPR used to be, was simply called a technical regulator, which has no visibility around economic or commercial regulation. So what that did to Nigeria was that it weakens the ability of the regulator to create value, because if I give you a typical example, if I give you a field development plan approval, that means my field development plan approval does not or may not necessarily translate to an FID for that field development plan to be sanctioned. Why? Because it's only an approval that fulfills the technical requirement in terms of subsurface and facility engineering requirement to mature the field, produce the hydrocarbons, and evacuate them to the market space. So when you get that from the defunct DPR, you now have to go and talk to NAPIMS, because that's where the investment space lies. That's where the commercial space lies. And PIA said no. If we are to be effective as a regulator, if we are to create value for all stakeholders, you should have visibility around the technical perspective and the commercial framework also. So that when you give an FDP approval, that field development plan is not only a field development plan that fulfills technical requirement in terms of geosciences of subsurface configurations, but it is also a field development plan that fulfills present economic realities that underpin the desirability of an investor to actually migrate to the point that he can put money on the table and implement the FID. That's a significant amount of difference. That's within the regulatory space. Prior to now, there was no transparency obligation enshrined in the regulator. But today, the regulator by law has to be transparent, has to be accountable. Now, if you move to the commercial space, NMPC, everybody knows, was simply a government corporation. Now, the law said, okay, NMPC, do business, generate money, run money, remove your costs, and pay everything to federation account. So that means when NMPC needs to invest capital, it has to go back to government handcapping, asking government, I need this amount of money out of the money I give you. And then because the money that NMPC remits to federation is a federation money, then government will look at it from a global national point of view and say, well, you are asking for $100 million, I can only give you 10. That's what basically led to the so-called cash call areas that up to now, we are still struggling to basically get them through. Now, so PIA prescribed that, look, NNPC, you have to be a limited liability company. And today, definitely 2-3 days ago, NNPC was unveiled as a limited liability company, and that set stage for a brand new mechanism of getting NNPC to profitability and accountability. So thank you.
Thank you very much for sharing with us those key differences. I picked the clear separation of roles, which is very important, independent regulation, the issue, provisions around transparency, as well as the regulators having clear visibility of what's happening in the sector. I wonder if Mr. Awachukwu could chime in on that. In addition, another issue I'd like for you to address is why, in terms of regulation, we have two separate regulatory institutions. That was a debate that was ongoing all through the time that the PIA was in process. And when the government issued the petroleum policy in 2017, it appeared they had opted for a single model, and then the PIA came and we saw a dual model. Can you share with us what the rationale is and the advantages from having an agency oversee the upstream while a separate one oversees the midstream and downstream?
Yeah, okay, thank you. So I think there was a perception prior to the passage of the PIA that the midstream sector in particular was a section of the value chain which was underutilized, not well considered, and basically forgotten about. The PIA really tries to focus on the development of the midstream sector, because taking a look at it, that is the future. That is where the jobs will be. That is where the ability to create economic value for Nigerians in general will be. The upstream it's a really closed environment, even in terms of employment and opportunities. But across board, midstream and downstream is something that everyone, can have a piece of the pie and play in. So I think that basically led to the thinking, have a regulator that focuses on the midstream and downstream sectors as an enabler for economic growth and prosperity for the country. I think Habib has really said it all in connection with the separation of roles. We now have a clear policy, clear regulatory agencies, and a clear commercial-driven entity, rather than what we had, which was a hodgepodge of everything. The minister sat on everything. NNPC was both a commercial commercial enterprise and also a regulator, and then the defunct DPR sat under the NNPC in terms of legislation. Thank you.
Thank you very much for that. I think a question that then comes out is what challenges could this dual regulatory model possibly bring? And I'd like to turn to Dr. Adefulu. In your experience, or through the development of the PIA and what you're seeing now, what are the challenges that you see in terms of implementing the PIA with this with the dual regulatory model?
Thank you, Jumoke. First, I think that the title of this session is actually very apt. By talking about making it work, we're not really focused on critiquing the bill, but focused on implementation of the bill and working together to make sure that, sorry, I keep saying the bill. I think many of us that have worked in the industry still have this problem, but making the act work. And when we go back to some of the challenges around implementation, particularly in relation to what we say multiple regulators, and some of those things we are seeing in practice. And I'd like to touch on one, maybe two things that we've seen. The first is around what you call integrated development. And those are assets which are upstream and have perhaps some midstream, mostly midstream components. And how do we make the regulation of those assets work in a seamless manner? What we've had is the bill, the act, maybe section 8 of the act, talks about those integrated developments and says, for example, the NUPRC will be responsible for the regulation of those integrated developments. But in reality, one of the challenges we have arising from the provisions of the act is that the NUPRC does not have explicit functions under the act to issue licenses for terminals or issue licenses for storage. And those are midstream functions. And those licenses are explicitly, or the licensing power is explicitly given to the NMDPRA. So that's a challenge that we have. Another challenge that we have is that arising across that value chain, there are a number of things around environmental remediation, for example, around perhaps decommissioning and abandonment, for example, that will cut across the upstream and the midstream. It may indeed even go into the downstream. And the way in which regulator A, that is the NUPRC, will treat those matters must be consistent with regulator B, the NMDPRA. And so those are some of the challenges that we are seeing in practice. I am sure that the representatives of NMDPRA and NUPRC will speak to some of the solutions that have come up, but I just thought to highlight those. Thank you.
Thank you very much for highlighting those issues. I'll come back to Mr. Nwachukwu on that. But first, I'd like to hear from Ms. Taiwo on where she sees where she has seen these challenges in her dealings with the regulator.
For me, I think the examples that Dr. Adeoye gave are really spot on. One of the challenges that we've got in the oil and gas industry is the issue around multiple regulators. And so you've got, for example, if you have to file certain documents, you find yourself filing them, maybe, for example, in Ministry of Environment and then in DPR and stuff. So again, while we appreciate the value of the separation as explained by Charles, regarding the separation of the NUPRC and NMDPRA, there is a concern around the sort of report outs and regulations that you would be getting. You want something seamless. You want to ensure that whatever it is, it will not create more hardship, or should I say inconsistencies or uncertainties for operators in the industry. So that's just to buttress on the point that was made earlier.
Thank you very much. As many of us will know, though, there recently was an issue as to who had regulatory powers to regulate terminal operations. I'd like Mr. Nwachukwu to talk about that and how that matter has been or is being resolved.
Okay, thank you. Let's have an understanding of where we were and where we are today. Dr. Habib has given, and Dr. Habib and I have given you a brief outline as to what the issues were and where we are today. As we go on, as with anything that starts anew, there will be teething challenges, but there are mechanisms embedded in both the PIA and in the relationships between both agencies to resolve those things. some of these resolutions are already taking place, and others will continue to do so. These are just early days. What we'll find is that change is a challenge for a lot of us. Change is a challenge for even our partners, the IOCs, the companies, midstream, downstream, across the entire value chain. Over time, I'm pretty confident that all these issues will resolve them. As you said, certain measures have been taken to resolve some of these things, and in due time, those measures will be made public. Thank you.
Thank you. Like Mr. Irikara said in the earlier session, there has always been issues around conflict over regulatory powers, and there will always be. I think the most important thing is that they are resolved as the issues evolve, and the PIA provides a mechanism for that in Section 3 that allows the minister to give policy directions on issues relating to the cooperation of the two regulatory agencies. So I'd like to turn to Ms. Taiwo now. Can you just describe to us what as an operator, what your working relationship has been like with the institutions created so far?
Okay, I think it's a very simple answer, and that is that it's still early days because the two regulators are essentially new entities. But we've had reasons to engage both of them regarding the regulations that have been coming out based on the PIA, implementation. And the thing that stands out from the engagements that we've had is that you see a clear interest on the part of the regulators to work with the industry. They are open to hearing comments and taking on board advice or suggestions from the operators. So, like I said, it's still early days, but based on the short engagement that we've had, during the discussions around the regulations that are coming out, I think it's actually quite good, and it's something to look forward to.
Okay, Mr. Wachukwu, would you speak to that?
Yeah, Tola, thanks. Like I said, the industry has not, relationships with the industry have not changed. Shell is Shell. We've been talking to Shell. Chevron, we've been talking to everyone, all companies. That's an important part of my remit. The PIA provides something that the Petroleum Act did not, the ability to consult with your stakeholders. Before, the practice was that with just a regulation to be issued, with no, and being honest, with no thinking on our part. I used to be in the DPR, with no thinking on our part with regards to, possibly how that might play with the sector, in the sense that we would simply make a regulation. There was no opportunity for anyone to come back to us before the regulation was made. Now we have robust engagement with all our partners. For the authority, we've issued 10 regulations. We're going to have our stakeholders consultation forum right here in this hall, 1st to the 4th of August. Prior to that, we've asked all our stakeholders and everyone, the general public, to make their comments on our website. I'm pleased to say we've received extremely well thought out feedback on what we've put out there, and that feedback will definitely go into the regulations. So 216 is a game changer for all of us. It gives us the ability to talk. The most important thing in regulation is that I think a gentleman from, I think it was Nate that made that statement earlier on here. We're moving to an era of self-regulation. We want people to actually do the right thing without anyone being a policeman. We want to enable business. We want to have growth in the sectors that would add value to this country. We've got loads of unemployed Nigerians. In a previous life, when I was in DPR, I was coordinator for the Oil and Gas Alternative Dispute Resolution Center out of Lagos. And I had engagements with loads of young people. Their concern, this was even just shortly prior to the passage of the PIA, their concern was, look, we're told that there are no jobs. We want to own our own businesses. We want to own our own small enterprises. We want to come into this business, into the oil and gas industry right out of uni. And all we ever hear about is NNPC. Then we didn't know anything about the DPR. All we hear is NNPC, Chevron, Shell, blah, blah, blah. We want to come into this sector, and we want to learn. We want to set up our own small businesses. So for me, I think the PIA, that's one of the key things about the PIA. It enables people to come in at every level. It provides counterpart funding in the Midstream and Downstream Gas Infrastructure Fund to de-risk investments. It gives opportunities across the entire value chain for people to come in. Thank you.
Thank you. So before we move away from the institutional framework, I'd like to ask Dr. Adefulu a question. So earlier this week, NNPC Limited was launched. And so we're now seeing the birthing of a commercially focused national oil company. I'm wondering if, are you optimistic about what the future holds in this regard? Are there things that you're excited about? Are there areas that you're concerned about that needs to be looked into?
Thank you, Jumoke, for setting me up with that question. Look, the Act provides for the incorporation of NNPC Limited, and it's a good thing. And when we talk about what Dr. Habib was talking about earlier, when you separate the role that government plays within that sector, and NNPC Limited is meant to play the commercial role, it's great that it's been incorporated as a limited liability company. There are, I think, some challenges, perhaps maybe paradoxes that are in the PIA that need to be addressed, and I'll talk about 3 of those challenges. The first is that we have a governance challenge. When you have a limited liability company, one of the reasons you do so is to ensure that the governance framework for limited liability companies apply to this national oil company. And one of the key things about the governance framework is the way in which the shareholders interact with the board, and the board interacts with the executive management of the entity. Now, unfortunately, I feel the PIA skews that interaction. Firstly, we do have 2 shareholders, and that's good. Those 2 shareholders are essentially government entities. Again, we should talk about that. But beyond that, the shareholders have no role in the establishment of the board, in picking the board members. That role goes to one person and goes to the president. And what that means, and that would include the executive members of that board, including the MD, CEO, and any other executive member on the board. What that means is that it weakens the relationship between the board and the MD. The board is unable, in my view, by the provisions of the PIA, to fire the MD. And that is a weakening, I believe, of the governance framework. One other challenge that I have with the provisions of the PIA in relation to the NNPC Limited is the fact that it has kept, in particular, one regulatory function. So production quotas that will be allocated to ostensibly to people who are its competitors. Those production quotas will be determined by NNPC Limited acting in conjunction with NUPRC. That's a weakening of the competition framework that is allowing it to continue in a quasi-regulatory function. And that's one of the challenges I have. One final challenge that I would mention is that in terms of competition, the provisions of Section 84, but in particular Section 84(4), I think also weaken the competitive framework. And what that, I would say in summary, does is if NUPRC calls out for a bid to award oil and gas licenses, NNPC Limited can basically sit, fold its hands, wait for company X, Y, or Z to win the bid, and through its role as the principal holder of government interests, will have a right to participate in that asset up to 60%, of the interest in that asset. And that right of participation comes up to, you will have expended funds, not just winning the asset, but in exploring for the asset and in developing the asset as well. It's a carried interest. And I think that weakens the competitive layout for NNPC. And if we look at countries in which this kind of corporatization has happened, for example, in Brazil, Petrobras was required to compete with the other oil and gas companies in winning assets as well. So that kind of lays out three challenges I believe that we have in relation to NNPC Limited. And I'll hand over to the moderator.
Thank you. So what I hear in a nutshell is that there's nothing to be excited about.
I didn't say that.
Okay. Well, I hope we have opportunities to discuss these issues and find solutions to them. So moving away from the institutional framework, I want to come to a topic that is a hot burner topic. A lot of questions on the WOVA app, at least 5 questions speak to this issue. And basically the PIA provides that the prices, the wholesale and retail prices for petroleum products will be based on free market prices, and essentially they'll be deregulated. But we still continue to see regulated prices almost 12 months after the passage of the PIA. To maintain these regulated prices, it comes as a huge cost to the nation's treasury through the subsidy regime. Isn't this a contravention of the PIA? Well, Mr. Nwachukwu, what do you have to say? And what's the pathway forward? What do we expect as a pathway forward to true deregulation, once and for all?
Let me preface this by saying that whatever I say here are my own thoughts. I'm not that of the authority. All right. The PIA speaks of and to a deregulated market. That is the law. We all know that. There's nothing wrong with that. And it's a good thing. However, as a country, we're not insulated from the geopolitical realities of the emerging economic order. And everyone in the world, all nations, have a duty to basically ensure energy security, sustainability of supply, and the interests of their people. Nigeria is no different. For now, we have to ensure that supply is consistent, is available, and available at a price that does not do our economy harm. But the PIA does speak to deregulated markets. And there I stop.
I will not probe any further. but I'm sure Dr. Adeflu would like to say some things.
I am fully supporting Charles in his. No, look, I think the point to emphasize is we're spending a significant amount on subsidies. There's a question as to whether all of the PMS is actually being used within Nigeria. And if that is not the case, potentially we are using a part of our subsidy to fund other countries' use of the petroleum that lands within our shores. There is a question of the value for money. Is consumption subsidy the best form of subsidy for people? It works great for people who drive SUVs, 3.5 liters, 5 liters, 7 liter SUVs. But the man on the street who hops on a bus consumes per capita much, much lower PMS. So it is a problem that we have postponed for too long and we need to confront. And we thought we had confronted by virtue of the provisions of the PIA. But clearly, that is not the case. The suspension of the provisions, which has not been done formally, by the way, the suspension of the provisions around continuation of subsidy, that hasn't been done formally. And we really need to challenge the need to do that. But again, in the context of energy security, as Charles has very eloquently, talked about, there is a discussion, but the discussion has to be moving away from continued subsidization and needs to be moving to a sustainable use of the limited resources that we have. Thank you.
Thank you. And now the screen is red. Our time is going. We have less than 20 minutes left. I'll move on to another area, and this is in relation to energy transition. We've heard in the news over the past week, the heat waves in Europe, the fires, and if I wasn't scared before, I'm scared now. So the federal government has said that its pathway to net zero is leveraging on its vast natural gas resources as a transition fuel. We have the Decade of Gas initiative that is built around this, with the aim of ensuring that we have a gas-based economy by 2030. We've heard recently, it's been reported that, I think this was the MD of NLNG, that Nigeria would need at least $2 billion of investment yearly to achieve the goals of the Decade of Gas initiative. Can you speak briefly on how, I'm sorry, the timer went from 19 to 4 minutes just now. I'm confused. That's the time. Okay. All right, okay. If you can briefly, maybe just very quickly tell us how the PIA will encourage gas development. Yes, you, sir. Yes.
I thought that'd be taller. Okay. Right. So, as I said earlier, my view has always been that the PIA speaks to development of the midstream, which is really, really gas. So it speaks to infrastructure, improved tariffs, a regulated and unregulated market for domestic gas demand obligations and requirements, and even support. We have the MGDIF support de-risking of gas infrastructure. I think it is most important now that gas is just not a fuel for us, it's also an economic earner for us, and we have to really, really build on that. as our transition fuel. Thank you.
Thank you. I'll turn to Ms. Taiwo now. What other ways do you see that the PIA encourages this? And as an operator and a developer, what are the concerns that you see in its implementation?
Yeah, you know, it's one on the one hand, you find the point that Charles has raised, which are exactly what the PIA is out there to do. On the other hand, there is also the issue around investments and what it is that how you need to encourage investments in this market, right? Presently, you've got a regulated gas market, right? And it's moving, the idea is to move it from a regulated one to a deregulated one where you find willing buyers and willing sellers, you know, to acquire the gas. He also mentioned issues around tariffing. Again, you've got to consider issues around the cost of actually putting down the infrastructure for the transportation or movement of gas. And in as much as the PIA itself is much more, I mean, provides much more for gas development and the midstream activities. One of the things that we as operators are concerned about is what is the obligation that is now being placed on should I say, the operators of these midstream assets. Some of these midstream assets are assets that are moving from upstream, because, you know, before the PIA came into effect under the Petroleum Act, you've got essentially integrated upstream activities. So part of what is now midstream under the PIA used to be upstream activities as well. So issues around, for example, your pipelines now, you know, you're going to start looking into third-party accesses, or for the bigger ones, or you're going to start considering things around open access. So investments, the bill is there. I mean, the act, sorry, is there. It's good, but there are other underlying factors that one also needs to think about. The security, the certainty of business in Nigeria to encourage investments in this space as well. So those are really key things to take into consideration. Yeah.
Thank you very much thank you very much for highlighting those. So I have 1 second, 0, time is up. I'm wondering if I can either ask him to give closing remarks, or take one question. If I can just take one question from the audience, okay. So would anybody like to ask a question? Okay. No, you're not out of the woods yet. We have the Wova app. Okay, so there's a question here that says, would you say, this is from Ifeanyi Okonkwo, would you say in your opinion that the new changes to the Petroleum Act has brought more good than harm to the economy?
Okay, let me start. I think, first of all, the changes in the PIA has the potential to do more good. The principles behind the PIA was actually to improve on the Petroleum Act, which has been a law created in 1969, I think. So it really was time for us to actually move to something more current and that addresses the issues of today. So from that perspective, definitely the PIA has the potential to do more good. But with everything, because the PIA is now even a much more detailed legislation, as they say, the devil is in the detail, right? So in trying to work it out, you've got gaps here and there that we have to work on and ensure that we actually fix. And I think that those are the things that we're looking at with regulations and guidelines. And to the extent that both regulators and operators are willing to work together for the interest of the industry. I think that it's actually work in the right direction.
Thank you. We have another question also on the WOVA app by Peter Olalere, and he's asking that what pathway does the PIA provide for local refining of petroleum products, especially in the light of importance of energy to the economy? I'd like to ask Mr. Nwachukwu to take that question.
Okay, so again, that's one of our functions. I can say that we are releasing our petroleum refining regulations. It speaks to opportunities for local refiners, legal local refiners, and provides, I think, quite decent incentives to get people to invest in that space. I know the concern has always been about how do such local refiners get crude, and I think those issues are being addressed at the appropriate level. But really, the idea, as much as possible, is to get as many refineries as we can, modular and otherwise. And I think the emerging framework, which should be published in a few days, I think, on refining regulations will speak to that. Thank you.
Okay, so time is fast spent, and I've been given the sign that we should end this now. And so we can't take any closing remarks, but I'd like to thank our panelists for the insights they have shared, for taking the time to be here. Special thanks to the technology team for allowing our virtual participants to participate without any hitches. And thank you to the organizers for giving us the opportunity to be here.